information technology policy. Also in Washington, we have Wayne Rash. He is a senior analyst for eWeeks Labs. And in New York, we cross to Jason Mazzoni. He is the Gerald Bailyn Professor of Law at Brooklyn Law School. All right, gentlemen, this is Crosstalk. That means you can jump in anytime you want, and I very much encourage it, okay? Wayne, if I can go to you first, to what degree should Internet companies be involved, share responsibility for curbing piracy in light of the law that is in front of the laws that are in front of Congress right now?
Well, I think Internet companies have a responsibility to not knowingly participate in pirated information or information for which the copyright use is in question. In other words, if they know that something is being used illegally, then they obviously should not allow it to be on their sites. But, you know, most Internet sites don't have a way to know what's there. Most of them simply act as what you might call giant receptacles of data. And as a result, they don't specifically look at what the content is unless somebody complains about it. So they have a responsibility if they know that it's illegal, but they may not know.
Jason, what do you think about that? I mean, to what degree should Internet companies be held responsible? Because if you're a website like YouTube, I mean, I've talked to people at YouTube. It is very, very hard to police it because so many uploads going on through every hour, and we're looking at through the course of months and years. It's a huge number of videos being put up, and I know of a personal example where I asked to have something taken down, and within an hour, YouTube did it.
Yeah, so YouTube is an interesting case because it actually, I mean, it has the resources
right.
to do things that many other companies might not have. So, you know, that's one thing to keep in mind in talking about YouTube. In terms of the current system that we have, YouTube is, as you just suggested, pretty responsive, and we do have a system under current law that allows a copyright owner to notify YouTube or another site that somebody has uploaded infringing content. YouTube has largely automated the process for reviewing that, and it's able to take down material in response to that site. In other words, disable access to it pretty quickly in a matter of hours. Now, there are a lot of complaints about perhaps too much content is being taken down, but in terms of YouTube itself, because it has the resources to do it, because there is a process by which a notice can be sent, a fairly straightforward notice by the copyright owner, that system, from the perspective of copyright owners, I think works pretty well. I mean, some things do get through the gaps, but YouTube, I think, is doing a pretty good job, and is doing it because of fairly simple procedures and legislation. The problem with SOPA is that it would radically change that system and impose much more burdensome requirements upon YouTube. And when you start talking about smaller sites, smaller entities that don't have the same kinds of resources, the costs could be tremendous.
Daniel, what do you think about that? I mean, let me go to Daniel first.
That's completely not true.
Go ahead.
Yeah, you know, the SOPA, the legislation that's being introduced is specifically not targeted at sites like YouTube, and that's kind of the whole point of this. YouTube isn't the problem, and there are existing laws to deal with that, and YouTube's a very responsible actor in that sense. The purpose of SOPA, the Stop Online Piracy Act,
so how can you explain YouTube's massive opposition
to foreign infringers?
Jason, you want to reply to that? Go ahead.
Well, YouTube obviously doesn't. Yeah, well, YouTube obviously doesn't think that. I mean, yesterday we had, which was Thursday in the United States, we had the Internet Blackout Day, where thousands of American-based domestic Internet companies, including Google, Facebook, and other large entities, opposing SOPA on the grounds that they are very concerned about the potential burden and possible liabilities under the statute upon them. These are pretty savvy entities, so it's hard to explain if the sponsors of the bill are so certain that there's no risk to a company like YouTube, why there would be so much opposition among domestic technology companies, mainstream technology companies like YouTube, Facebook, Boing Boing, all kinds of other entities that are really a staple part of the of the internet as we know it today. They are vehemently opposed to this statute, and they're not opposed to it just for ideological reasons. It's because they see serious business consequences for, for them.
Let's look at some of these consequences. Wayne, I mean, we know a lot of the backing of these legislation comes from the content industry, particularly the film industry and music. But why should the entire internet be changed to cater to their needs? Or is it because Hollywood is paying politicians on both sides of the aisle? These politicians realize they've taken the money, now they have to follow through, and a few of them actually realize they didn't read the legislation and they've backed away from it in the last 48 hours. I mean, to what degree should the internet be changed for a small number of people here?
Well, the internet should not be basically dismantled from the way it works because of, the fact that Hollywood is scared of technology.
Yes.
This is one of the problems, is that what you've got here is a situation where YouTube, for example, to use an obvious example because we've been discussing it, could, under the way SOPA is written, be actually taken offline because somebody alleges that they've got copyrighted material on their site.
That's completely not true.
This is in spite of the fact.
That's completely not true. If you look at the legislation, it's only directed at foreign infringing sites. Only foreign infringing sites. So no domestic site, no site in the United States could have action taken against it.
Yeah, but the people.
And if you look at the manager's amendment
people
of
at
the bill,
YouTube
which
are
was
obviously
introduced
worried
back
that
in
it will
December,
still be used against
they took
them.
out all of the DNS blocking provisions, which are about taking down sites.
Yeah.
So taking down sites is out of the bill.
Yeah, because DNS blocking would have.
Wayne, go ahead.
DNS blocking would have interfered with a whole bunch of security issues. But the fact is it is still aimed at sites that could be taken down because someone alleges, without any real actual process, that they've got copyrighted material there. Now, here we are talking about taking down
That's not true
a
either.
site.
You would have to get a court order first.
Yes, you have to get a court order, but you don't have to prove anything.
Simply not the case that you need a court order.
And you don't have to have any due process.
Okay, Jason, jump in. Jason, jump in.
Yes, but you do have to go before a judge.
The government, in order to require intermediaries to stop dealing with sites that the government is targeting, does have to commence an action with the court, and it's a fairly simple process. You simply need to file the paperwork. Private entities, in order to shut off funding, payment processing by Visa, MasterCard, PayPal, other entities that really the lifeblood of many of these sites. In order to shut down their transactions, private entities don't have to go before any judge at all. They simply have to send the notice. Within 5 days, a very short period, the recipient of the notice, Visa, PayPal, some other entity that is providing payment, must disable transactions. There's no judicial review before that happens. There's no opportunity for the site to go for a judge and say that it's not true that we have infringing material. This is completely contrary to how we normally regulate speech in the United States. There's no other instance in the United States where a private entity can shut down communication simply by sending a letter off to.
Go ahead, Daniel. I mean, if I could just sum it up. I mean, from what Jason just said here, there's no due process. That's what he's saying when we look at this legislation.
Yes, exactly.
Yeah, which is what I was
no judges reviewing
what we're trying to do.
Already have in their terms of service.
Gentlemen, let's let Daniel go. Go ahead, Daniel. Go ahead.
Yeah, these are companies that already say in their terms of service that they will not do business with criminals. They say in their terms of service that you can't use, for example, a payment processor. We don't know whether they're criminals.
There's no judgment. There's no judgment by any court of criminality. There's no judgment of any violation of copyright. This is the problem.
That's doing any other illegal activity. And when they learn about it, they shut down those sites and they stop doing business with them. So right now, this actually increases the opportunity. The
problem is there's no judicial judgment. There's no court deciding any of this.
Because now it goes before a judge.
Okay, Wayne, where do you jump in on that one? Go ahead.
The only people...
Well, I was trying to earlier.
Go ahead.
Well, the fact is what we're trying to do is enforce U.S. copyright law on foreign companies whose copyright laws may be different from ours.
Right.
And what we're saying is if you don't follow U.S. law in terms of copyrights, then we have the right to shut you down. And whether it's through withholding payment, whether it's through telling a search engine you can't deliver results, we're no longer have the DNS blocking. But the fact is that, this is what we're telling people, is that you have to follow U.S. law, regardless of what the law may be where you're physically located. And that's part of the problem. The other part of the problem is, effectively, is that it gives a private individual a way to essentially...
you're objecting to the fact that people are trying to stop sites that are pirating American intellectual property. And it's not always just movies and music. It's also physical goods that are counterfeit. These are counterfeit drugs.
Yes, there are. And there's also written material, including mine.
Harm infants, harm children, harm adults. This is serious. There are serious consequences.
Well, it's one thing. It's one thing to object to these sites, but the problem here. The problem here is in terms of how you go about remedying the problem if there is a problem that should be remedied, particularly if you're talking about a remedy that imposes very significant costs on the rest of us. I don't think the content industries have explained, and this gets us back to really the very first questions with which we started, why it is that the rest of us should suffer all of these very serious consequences in terms of the interruption to the structure of the internet, in terms of the censorship of sites, in order to protect the interest, legitimate interest.
Okay, Jason, I'm going to have to jump in here. Gentlemen, we're going to go to a short break, and after that short break, we'll continue our discussion on protecting the internet. Stay with RT. To remind you, we're talking about the Stop Online Piracy Act. If I can return to you, Daniel, it seems to me, and correct me if you think I'm wrong, that we're using status quo tools to fix a problem in its piracy on the internet. But isn't it because the internet is uniquely different than other types of piracy that we should have a unique answer? And the legislation that is going through Congress is really kind of backward-looking and not forward-looking. Couldn't we get something that's more innovative, that works with companies instead of something that is so? It seems to me that we're using a sledgehammer when we should be using a very fine surgical instrument to solve this problem.
Well, you do need a multi-pronged approach to attacking this issue. It's not going to be solved by industry alone. It's not going to be solved by government alone. But one thing that you can do is go after the economics of piracy. You have to look and see how these sites are being run and where they're making their money and how they're drawing an audience. So the way to cut that off is to cut off their sources of funding. Go after the ad networks, go after the payment processors, stop linking to these sites. And this is really going after the worst of the worst, the foreign infringers that right now are outside of the jurisdiction of the United States and we can't do anything about. This is a way of saying if you're an American company and a court finds that identifies a site as being a rogue, malicious site, then as an American company, you'll stop doing business with them. I think that's part of being a responsible player on the internet.
Jason, what do you think about that? Is it just too overarching? It should be much more specific, much more nuanced in dealing with this issue? Because it seems like the way, and I want to talk about freedom of expression later, is that it can be, the way these laws are being proposed, there's an enormous amount of abuse could be out there in using these laws, as you pointed out in the first part of the program.
Yes, I mean, a big part of the problem here is that we're relying upon assurances by copyright owners, and particularly very wealthy copyright owners, that they will act in a restrained way. Unfortunately, the history of their behavior does not bear that out. Copyright owners routinely exaggerate the scope of their rights, go after websites that are not infringing or are using content in a way that is protected by the fair use provision of the U.S. Copyright Act. Copyright enforcement tools are often used just to shut down competition rather than to pursue any legitimate copyright claim. We shouldn't be dependent for our system of copyright enforcement upon the copyright holders acting in good faith, which is what SOPA is really built upon. There are too many public costs in play, both in the copyright system in general, but particularly when you're talking about monkeying around with the internet and all of the implications for freedom of expression that come from censorship. And so I think that you're quite right to suggest that a much more nuanced approach is appropriate here. And I think we're going to get something like that. I mean, the SOPA right now reminds me a bit of the Italian cruise ship that capsized recently and the captain abandoning the ship. I mean, the legislators are sponsoring the bill are abandoning it as quickly as they can. In its current version, it has no chance of going through. So I do think, and this is true in part because of pressure from the White House, which has expressed many problems with the statute from its perspective. So I think we are going to be going back to the table. And going back to the table does, I think, mean engaging in a serious way with technology companies. They were not part of the legislative process in the same kind of serious way that they should be. And I think that recent activities have demonstrated that they really have a strong position now. They obviously have resources to lobby and to put forward their own views, and all members of Congress are going to really have to take account of that. It's important, though, to keep in mind that that the copyright owners and technology companies are only two sort of sets of stakeholders. We also have ordinary members of the public and users of consumers of copyright materials.
Okay.
So I would hope that any process going forward would be inclusive of them as well. We just have not had an inclusive process. This
it's very interesting that you mentioned that, Wayne.
Industry insiders.
If I go to Wayne here, I mean, I think it's, Jason, you bring up a very interesting point here. I mean, SOPA, do you think the industry wrote it and sent it over to Congress? Because just as Jason pointed out, and I said earlier in the program, I mean, a lot of politicians in Washington are walking away from it, even though they used to be supporters. I mean, did they actually read it, or did they listen to their constituents? And did they listen to these technology companies for a change?
I think what happened is two things. One of which is, I think we should make it abundantly clear to the people who are watching this program that both SOPA, the Stop Online Piracy Act, and PIPA, the Protect Intellectual Property Act, are both dead. They are not going to go through either the House or the Senate this year. They will not be signed into law this year. So they are dead. The chances of this becoming an actual issue this year are non-existent. However, that does not mean they won't come back again, sort of zombie-like, to rise again and bother us all a year from now. So the issue is that the movie producers, the record producers have a lot of lobbyists, and they managed to get a law through that they wrote that gave them everything they wanted. And because of the fact that they had some well-paid lobbyists who were very effective, they managed to get hearings and managed to get it as a proposed bill. Only one company was actually invited to testify at the hearings that was not from one of these groups, and that was a person from Google who was invited to testify. No other internet-related company was invited to testify. This shows you that this bill was very one-sided from the beginning, and it's not surprising that it's now dead. But the fact is, it should never have been brought up in this way in the first place.
Okay.
So the fact is that.
All right, I was going to go to Dan. I was going to ask Daniel, what's Plan B then, if both are dead?
Well, you know, I think if you look at the alternative bill that was introduced, the Open Act, that was introduced by really the kind of opponents of SOPA and PIPA, there's a lot of similarity between the two. So where SOPA had going after the ad networks, going after the payment processors, search engines, and blocking sites through DNS, the Open Act just goes after the ad networks, and it just goes after the payment processors. And so there's actually a lot of agreement from both the tech companies and from the content industries that going after the ad networks and the payment processors is the right way forward. So I wouldn't say it's dead. I would say that the provisions that have been taken out about blocking, that's dead this year. You know, that's really completely off the table. Whether or not search engines will be included is an open question, but I think there is a lot of agreement that it's an important problem, and the White House statement said something should be done this year. So I wouldn't say that it's out of the question to have action on it, and I think it would be a fair compromise, which is kind of the point of Washington, is to come together and find, you know, room for agreement and to say, well, at least we can go and have ad networks and payment processors stop dealing with these known bad sites.
Jason, if I can ask you, I mean, to cut down. Go ahead, Wayne. Wayne, jump in. Go ahead.
Yeah, it's not going to. the Open Act isn't going to pass this year either, not because it may not be a good idea, but because it's an election year. And right now, nobody in Congress wants to have something which happened yesterday happen closer to the election. It's just not going to fly. Now, after the election is over, that's a different story. But right now, this whole issue is currently dead. This is not to say that intellectual property doesn't need to be protected.
The House introduced the new open bill in the House, so I think they are moving forward with it.
Okay, I want to change gears a little bit here. Jason, if I can go to you.
The Open Act also...
Okay, go ahead,
yes.
Jason, jump in.
I was just going to say on the Open Act, an important distinction is that there's the availability of independent review before any of this censorship actually happens, which is something that I think is very important for protecting freedom of speech, and which is one of the principal defects of SOPA and the Protect IP Act, one of the things that the White House has zeroed in on.
Okay, Wayne, if I can ask you, I think it was pretty impressive the 7,000, maybe more sites went dark on Wednesday. I mean, what does that tell you about the power of the Internet now? I don't think we've ever seen anything quite like this before. I mean, is this a new political force, or at least a force of consciousness that in society where we can find consensus on something when we have such political gridlock in the United States?
Well, I don't think gridlock's going to go anywhere, but I do think that it shows that the Internet community can work together to a common interest, and I think that is what got the attention of Congress. I don't think anybody in Congress particularly cared that the sites themselves went dark, but they did care about the fact that there is the ability of the Internet community to work together to a common interest, and that they believe strongly enough about this interest to do something, which is in the way legislation works around here is really worth noting, because quite frankly, Congress is pretty out of touch with things on the Internet in general. Even now, sending an email to your congressman is probably not going to ever see the congressman. It's going to get seen by some junior staffer who will simply mark what you said down as a yes or a no, or a 1 or a 2 or something, and they will then not pass it on anywhere. So Congress is not that in touch with the Internet, but they are in touch with their constituents, and they also are in touch with the lobbyists.
Jason, you want to jump in? You want to jump in there, Jason?
Yeah, I was going to say I'd take a slightly more cynical assessment of what's happened in recent weeks. And what we have seen, basically, in terms of opposition to the legislation, is a convergence of interest between technology companies like Google and ordinary Internet users. And so you might look at that and say, well, ordinary people using the Internet have now found a political voice. They're organized in a way that hasn't been true in the past. I'm not sure that Congress is listening to them. I think Congress and the White House are listening more to the technology companies. And again, it's not entirely clear that the interests of the technology companies are reflective at all points in time of the interests of ordinary consumers. And so while the coalition has been highly effective in this instance, we'll have to wait and see how things play out in the next round.
Okay, well, it looks like a little bit like Occupy the Internet here. All right, gentlemen, we've run out of time. Fascinating discussion. Looks like we ended up on occupying the Internet. Many thanks to my guests today in Washington and in New York. And thanks to our viewers for watching us here at RT. See you next time, and remember, crosstalk rules.